Today we're going to talk about the differences between a revocable living trust and a will and why you might want one as opposed to the other. My name is Gregory Singleton. I'm an estate planning and probate attorney located in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities as well as Greater Minnesota alike. Now, the reason I wanted to make today's video, and I think it's an important video, is I don't like how a lot of attorneys address the question of whether you should have a revocable living trust or a will. They only look at the cost or maybe a few of the circumstances and don't explain why or what some of the advantages and disadvantages of both may be. So I'm going to try to get a little bit more in-depth than a lot of people go into about the differences between a revocable living trust and a will and why you might want one as opposed to the other depending on your circumstances. So we're going to break this into three parts. First, we're going to talk about probate and what probate is and what are some of the characteristics of probate. Second, we're going to talk about wills, and third, we're going to talk about revocable living trusts. So to jump right into it, probate. Now, I have to read this because it's the definition of probate that I was able to find. It says, it is the process by which a will is deemed valid by a court of law so that the estate can be distributed to the estate, the creditors, and the beneficiaries as appropriate. In layman's terms, probate is a process of giving away your stuff based on your will if you have one. There's a few characteristics which are pretty important to understand about probate before we get into what is in a will or what is in a revocable living trust. The first characteristic is cost. Probate has various costs associated with it. It is a court proceeding. There are filing fees, there are notice publication fees, there is attorney fees. These can be substantial if the probate goes on for a long time. There's also personal representative fees. Now, when I say personal representative, in Minnesota, we call the person that administers the estate and eventually distributes out the stuff the personal representative. In other jurisdictions, it's called the administrator or the executor, or if you want to get old-timey, the administratrix or the executrix for women. But no one ever uses that anymore. It just sounds cool, though. But in Minnesota, we have the personal representative. And in California and New York and some other jurisdictions, there is a guaranteed compensation paid to the personal representative. This can be a percentage of the estate, and it's usually on a sliding scale. So for the first $1 million of the estate, it'll be the personal representative will get 5% of the estate. And the next $1 million, they'll get 4% of the estate. And the next 500,000, they'll get 3% of the estate, and so on, etc. That can be a lot of money. And that's money that's not going to your beneficiaries, other than the personal representative if they are beneficiaries. So in Minnesota, all we have is that the personal representative is due what is called a reasonable amount. Now, in my experience, a lot of times people don't petition the court to receive a reasonable amount, so the personal representative doesn't ask for anything. The next consideration with probate is that time is time. It can take a long time, 6 to 24 months on average. It can take longer with COVID, though the courts are doing a spectacular job at dealing with their dockets right now and using Zoom and some other things to make their dockets faster. But while probate is going on, accounts are frozen, bank accounts are frozen. You can't access those funds. Real estate is frozen until a later point in the probate process when it could be sold. And then once it's sold, the revenue from the sale isn't distributed to the beneficiaries until the end of the probate process. So if you need access to money right away, anything that's in probate, would be it real estate, bank accounts, personal investment accounts, or whatever else have you, baseball card collection, they're going to be inaccessible for 6 to 24 months or even longer. The third consideration is privacy. In that, with probate, you have none. To start the probate, you immediately, one of the first things you have to do is send a will to the court, and the court will make that a public record. You can ask the court to make it a private record, but I don't think they ever have, and I don't think they ever will. So if you don't want people to know what's in your estate and who's getting what, then you need to avoid probate. The final consideration about probate is that there are several types. There are probate alternatives, such as transfer by affidavit, and those are generally for very small estates, but you can avoid probate and address the entire estate without having to go before a judge. There's informal probate, which is in front of a registrar, not a judge, but you may or may not need an attorney for informal probate. And then there's formal probate, which you pretty much definitely will need an attorney to guide you through the court process, which will be in front of a judge, or in some jurisdictions, a referee who reports to a judge. Now that we understand what probate is, let's look at a comparison between a will and a revocable living trust. And the key difference is that a revocable living trust will avoid probate. Now, I've already given you a definition of probate, but think of it this way. Probate gives away those things which you own and for which a beneficiary has not been designated. In a will, you own all your stuff, and there's no beneficiary designation for it until you die. So once you die, then everyone gets your stuff through the probate process. In a revocable living trust, you don't actually own your stuff. It may seem like a contradiction of words, but you put all your assets and all your things into the trust. Now, while you're alive, you own the trust and you control the trust. But when you die, but the trust lives on. So since you've put everything into the trust and the trust owns all your things, you have nothing to own to go through probate. So therefore, you're able to avoid the probate process. With that in mind, let's look at wills. There are some pros and cons to wills. The first one is it's a pro, they're easier to set up. They're easier to make, they cost less. I did a Google search and said, what is the average cost of a will in Minnesota? And Google came back with around $800 to $1,000. They're a one and done deal. You draft your will, you don't have to administer it. If you want to change it, you may need to get another attorney. You may need to get an attorney to make the changes to the will, to either do an amendment to the will, which is called a codicil, or to restate the will or redraft the will. But still, it's only going to cost you $800 to $1,000 to do. And if you have a small estate, you may not need to worry about going through probate. So for small estates, you can probably draft a will and keep it out of probate and go forward. The other thing you can do, keeping in mind that you can use a transfer by affidavit for very small estates, you can use a strategy of getting property out of your probate estate and reducing your probate estate down to the point where you can use a transfer by affidavit. The way you do this is you use, one of the ways you do this is use a transfer on death deed, or you use a payment on death account. This gives a beneficiary designation to real estate property or tangible things or to bank accounts. And with that beneficiary designation, it will avoid probate. And if you can strip enough things out of your estate by using these and other mechanisms, you may be able to shrink your estate down to where all you need is a transfer by affidavit. So that's one consideration. Another thing to consider is privacy. Now, we've already said with probate you don't have it, but why does that matter? Well, for a couple things. One is that there are companies out there who hire people to go through the probate records, find out who's going to receive a lot of money, and then they start hounding them. And they start saying, please give me money for my charity, or please buy this timeshare, or please use our services to help manage your money. There's also scammers out there. Since it's a public document, the scammers can go look at who's getting a lot of money in probate and target the people that are receiving the money. If you have a large estate and you want to protect your beneficiaries from this, you might want to avoid probate by using a revocable living trust. The third thing we've already talked about is your assets being frozen, but why does that matter so much? I can think of two cases right now, just off the top of my head, where frozen assets may be a problem. The first one relates to COVID. Now, as I'm videotaping this, it's December 2020. We're in the middle of the COVID pandemic, and if someone relies on you for an income and you die because of the COVID pandemic, they also may be out of work or unable to find work to support themselves, and they may need access to money until the pandemic's over. If you have everything go into probate for 6 to 24 months, they're not going to have access to funds. Now, the other situation, I think this is probably more common and more applicable to more people, is for single parents. And single parents are one group that I often recommend have a revocable living trust. And the reason for that is in your will, or pour over will if you have a revocable living trust, you will make a guardianship designation for your minor child. So if you have a child that's 9 years old, you'll say, I want Uncle John to take care of my child until she's old enough to become an adult. Well, it's a big financial burden to take on the raising of a kid. They may even need to move to a bigger house to accommodate having a kid. To do that, they are going to need funds. If you go into probate and all your assets are frozen until the end of the probate process, then I think John is the name I said, I forget. The Uncle John is not going to have access to those funds. Now, one strategy you can use, of course, is to get beneficiary designations on your retirement account. You can use life insurance as well. What you can do is you can make the life insurance and your beneficiary retirement accounts feed into a trust, which can be used, and that trust can be limited to the use for the health, education, maintenance, and support of your child, which will help finance raising her. So her or him. And so there are some options, but a revocable living trust is certainly one way that we finance guardianships. Now, looking closer to a revocable living trust, we've already said that the will is going to cost only between $800 and $1,000 to set up. And I did a Google search, and in Minnesota, a revocable living trust will cost between $1,200 to $2,000. I think most of the ones that I see are about $1,500. They are more expensive, but here's what a trust attorney, someone who only does trust, will tell you about the costs, and is what I'll tell you, because it is true. So we make a graph, and we have money on this side. We put a will right here and a revocable living trust over here. Now, a will is going to cost, say, that much money to set up, and a revocable living trust may cost more, may cost even double what it costs to be a will. And at this point, you may say, well, a will seems more economical. But because you go into probate, you're going to have to pay attorney fees. You're going to have to pay personal representative fees. You're going to have to pay court fees, and et cetera, and et cetera, and et cetera. And it can be many times the cost of a revocable living trust at the end of the day. So if you're looking at the big picture, maybe if you want to save money, a revocable living trust is the way to go. On the other hand, I have clients that just say, I don't care. Let my beneficiaries figure out what's going to happen with that. I just want to save some money at the outset. And in that case, they will use a will. We've already talked about probate and some of the benefits of the costs and the time. There's a couple other circumstances which you may want to consider using a revocable living trust. The first one will be for a second marriage. Now, a revocable living trust can be used to segregate one person's assets and income from another person's assets and income. And why is this important? Well, take, for example, if both of you have a child from a previous relationship. You can talk to each other and say, in our wills, I'm going to give you, whoever dies first is going to give their assets to the other person. And when that person dies, give all the assets split 50-50 between the two children. If that works out, great. However, if one spouse dies and just leaves a will and leaves everything to the other person, that other spouse may say, you know what? I never liked that other guy's kid, my former spouse's kid. I'm going to write them out of my will. So they redraft their will and give it all to their own child. They can play favorites. This is a big concern. There's also concerns about if this person gets married to another person. How is the money segregated? There's a lot of things you can do with revocable living trusts to, for instance, guarantee that your child gets an inheritance. There's a lot of different strategies that can be taken and a lot of benefits. So if you're looking at a second marriage situation, I almost always recommend using a revocable living trust. The third time that a trust may be useful is if you have a taxable estate. Now, on the federal level, in 2020, you have an estate tax exemption of up to $11.58 million, meaning that if your estate is worth less than $11.58 million, you are not going to be hit with an estate tax. The second you get any money above $11.58 million, then you get hit with an estate tax. And I think in 2020, it's going to be $11.7 million. So it's continually going up. Now in I believe it's 2026, that's going to sunset, and it's going to reduce down to about $5 million adjusted for inflation. But still, $5 million is a pretty sizable estate. In Minnesota, the estate tax doesn't kick in until $3 million. So if your estate is more than $3 million, you may want to use a revocable living trust to take advantage of some of the opportunities you can to avoid taxes. One thing to note is we are entering into a new administration, and this administration may say $11.58 million is ridiculous. We're going to reduce the estate tax amount to, let's say, the 1990s levels of $600,000, so that any estate above $600,000 is taxed. Well, that changes the picture a lot. At that point, you may want to get a revocable living trust if your estate is going to be above $600,000. But we're going to have to see what happens with the new administration. The final thing that you're going to you may want to consider a revocable living trust for, and I highly recommend it usually in these cases, is if you have property in another state. For instance, if you have a house in Minnesota and you have a cabin in Wisconsin and a cabin in North Dakota. Well, if you have a will only, or no will, you will have to go through probate, the probate process in Minnesota. Then you're going to have to get another attorney and go through the whole probate process again in Wisconsin. And then you're going to have to get another attorney and go through the whole probate process in North Dakota. That's 3 probates you're going to have to go through. However, if you have a revocable living trust, you can take all these properties, put them into the revocable living trust, and avoid probate altogether. That'll save a ton of money, time, and headache down the road. So it may make sense in these cases to have a revocable living trust. So that's, in a nutshell, that is the difference between a will and a revocable living trust and why it matters, and what are some of the considerations you may want to look at when you're making the decision for yourself. Should you have a will or should you have a revocable living trust? If you want more information on this, I have a blog. You can read about it on my website. I also have an informational sheet that I give to all my clients. If you're curious about that, send me an email. Otherwise, if you have some questions, feel free to answer or ask them in the comments below. And if you like what you saw today, please feel free to like and subscribe to help support the channel. Otherwise, until next time, this is Gregory Singleton with Signature Law.